Fifth District Court of Appeals in Dallas, Texas is now in session. Justice Bridges presiding.
I'm going to call the case in 05-19-01129-CV. William Nix individually and as representative of the state of Linda Noel Nix, deceased appellant, versus Charles S. Chang, MD, individually and doing business as Chang Neurosurgery and Spine Care Appellees. Normally, I would say that both sides are familiar how the court system works. We are in our third Zoom conference here at the Court of Appeals, and it is a little different. The timing remains the same. You'll start out with 20 minutes per side with a 3-minute warning. One of the screens is a clock. It will run down as normal from green to yellow to red. Of course, as it gets to yellow, that's the warning that your time is about over. When the red light comes on, unless there's a question from one of the justices or myself, it'll be a time to wrap up. The appellant will have 5 minutes for rebuttal with a 1-minute warning. I know that we're still getting familiar with this process. It appears that if you're not on, it's not your turn to speak, as one of the attorneys, if you'll mute your pad, then there won't be chances of less background noise during the Zoom conference. Additionally, since it is technology, if we lose someone during this procedure, we will pause and wait till Lisa Matz and Charles Matz can get us back on board and going. And so with that, I'll turn to the appellant. I'm not going to read your issues. You can be assured that we have read the briefs, looked at the record in this case. I'm just going to turn to you and let you jump to where you want to get started. So we'll get started now.
Thank you and good morning. May it please the court, counsel. I represent the appellants in this case, and as the court knows, this is an evaluation under Chapter 74 of the Texas Civil Practice and Remedies Code, the Medical Malpractice Act, an inquiry about the sufficiency of an expert witness report. Just to make sure we're talking about the same report, it is in the record at page 98, and that is actually the supplemental report of Dr. Carl Adams, and that is the report that is operative in this case and is the one that is subject to an evaluation by this court, which is essentially a de novo review and a review of whether or not the trial court abused its discretion in improperly applying the rules and the facts of the case and the legal requirements for a report. We suggest that that didn't happen here and the trial court should be reversed. Just by brief background, a few of the facts that are relevant here and worth noting is Mrs. Nix had entered the hospital, the specialty heart hospital, in mid-August for a surgical procedure of her heart. That procedure went forward, was completed, and within a few days afterwards, she suffered some subdural hemorrhage and bleeding complications. That required a neurosurgeon to be involved for evaluation, and that was Dr. Chang. And ultimately, the decision was made to transfer Mrs. Nix over to the Baylor Hospital, the regular hospital, for his care and management, which involved first performing a surgical burr hole procedure, which released and was meant to relieve pressure and bleeding. Those neurological issues and the neurosurgical issues in and of themselves apparently were completed without complication. The surgery went well, and that is not the criticism of our expert in this case. In other words, the operative factual inquiry here that is at work is the time period from August the 19th through the 31st, which has to do with the post-surgical management of Mrs. Nix by Dr. Chang, who was her admitting physician, who remained her admitting physician during this time period, and who was the physician in charge of her overall care during that time period. Mrs. Nix was never transferred back to the Baylor Specialty Heart Hospital, instead remained at the Baylor Hospital, where over the course of time, beginning on or about August the 20th through August the 30th through the 31st, she began to experience cardiac symptoms and complications associated with management of her hemodynamics. And these were symptoms that Dr. Chang addressed at some level on the front end with one consultation to a heart doctor with regard to Coumadin and management of Coumadin. And then once again, in the middle of this time period. And then on August the 30th, Dr. Chang actually visited Mrs. Nix and pronounced her good to go and ready for discharge.
Mr. Chase,
Yes,
Mr.
sir.
Chase, pardon me. I just have one question. On the date that Miss Nix's discharge was authorized, who was her treating or attending physician?
Still Dr. Chang.
Thank you.
And I appreciate that question, Your Honor, because that's where I was going. Ultimately, Dr. Chang determined that Mrs. Nix was in fact ready for discharge. The note reflects that it was imminent for discharge, which began to occur the next day, the next morning on the 31st. And as these folks at the hospital are disconnecting Mrs. Nix from monitoring, and she's getting dressed and undergoing her last round of some therapies and the like, she actually suffers a code. Blue requires resuscitation, which unfortunately was unsuccessful, and she died at the hospital literally while trying to get ready to leave the hospital on Dr. Chang's orders.
Mr. Chaikin, I'd like to ask a question. First of all, can you hear me?
Yes, sir.
All right, how are you?
How are you? Good morning, Justice.
I'm fine, thanks. So to follow up on what Justice Peterson asked, two questions so that I can then turn my microphone off. How do we know from the record that it was Dr. Chang that was still the one in control of her? And number two, the defendant makes a big point of lack of knowledge. How do we know from the record that he knew the facts sufficient to put him on notice that he should have either treated her cardiac issues or recognized he wasn't able to treat her cardiac issues and bring get her back over to cardiothoracic help?
And I appreciate the question, Justice Evans. And I think that the record reflects that Dr. Chang had interacted with some consultants on a couple of occasions with regard to the management of his patient. He remains the admitting physician the entire time and is the physician that actually initiated the discharge procedure. And the records reflect that. And I don't believe that's actually in debate. The issue with regard to what Dr. Chang knew or should have known, I believe is subsumed in the concept of actually the duty. In other words, Dr. Adams has opined that as the physician in charge and the managing physician, it's the duty and the obligation of that physician to monitor and to be aware and to recognize and respond to symptoms, or to have transferred Mrs. Nix back to physicians who were capable of doing so. And so the argument about what Dr. Nix knew or did, Dr. Chang, what he knew or didn't know, at some level, I think is a little bit misguided in the sense that if in fact, at the time that he met, for example, with Mrs. Nix on August the 30th, and there's a note there that indicates that she was sleeping, yet he still verified that he was familiar enough with her condition and her ongoing conditions and active medical conditions to presume that she was capable and ready for discharge when in fact she wasn't. And so I'm not sure at this stage of the proceeding or the inquiry, you can know for sure what Dr. Chang actually knew or didn't know, for example, only that what he should have known or was charged with and what his responsibilities were in terms of executing on those responsibilities. And I think just to follow up on that, Justice Evans, the Abshire case talks about that in a broad sense, which is that as you get farther and farther down the field here of the inquiry with regard to the sufficiency of these reports, the danger is that you start to get involved in merits-based arguments about whether or not somebody did or didn't do something correctly or incorrectly, or knew of something or didn't know of something. And those really are better issues that get resolved down the road in terms of actual discovery and the actual litigation of the case.
Yeah,
I hope I answered your question. Did I, sir?
Turn my mic back on. Yes, thank you very much.
I have a quick question. So originally she came to the hospital with these heart issues, and the heart surgeons did put the stent in. Is that correct?
Yes, sir.
And at that point, did they think that they had corrected the heart problems that she had?
As far as I can tell, and as far as the records reflect, the issue with regard to the implementation of the hardware for her heart procedure, they felt like at the hospital that it went well. I think there are some problems, and there were some problems that were addressed by Dr. Adams in this case previously. But at the time, the complication that Mrs. Nix ultimately experienced was an actual brain hemorrhage, a subdural hematoma.
And he fixed that problem. They had the surgery with a bore, right?
Yeah, correct.
Okay, and
Yeah.
so when did the heart problems manifest themselves again? I mean, is there clear notes in the nurse's records to him between the 19th and the 30th?
Yes, there are notes throughout the time period that recognize that Mrs. Nix is suffering from shortness of breath at times, complaints of chest pain, tachycardia, one-sided weakness. Those are spread throughout through the notes, and were certainly more prominent at or around the time that Dr. Chang had determined that she was ready for imminent discharge.
Go ahead, continue.
In any event, so Dr. Adams, produced a report initially. The trial court determined that it wasn't sufficient and gave a 30-day reprieve to file a supplemental report. Ultimately, the trial court determined that the report was insufficient and didn't comply with Chapter 74. The basis for the actual denial, or what the trial court determined was insufficient, is unclear from the actual order. It's kind of like a broad summary judgment order. And so that being the case, I just wanted to briefly cover all aspects of this report, as I believe it more than adequately meets all of the standards and requirements of Chapter 74 and all the attendant case law. And I'll try to highlight what I think are the issues given my time remaining. First of all, Chapter 74 requires only that there be a good faith effort by the physician providing a report in terms of providing a report and making the inquiry and making the opinions and the ultimate conclusions. It requires a fair summary of the issues in terms of the standards of care that are to be applied, whether or not those standards of care have been met or breached, and then how the failure to meet those standards of care have manifested themselves causally. It doesn't require a marshaling of all the evidence. It is not an actual summary judgment motion in the sense of deep marshaling of evidence or all of the evidence. It's really a fairly routine inquiry, and the requirements of these reports have been the subject of a lot of litigation over time. And the Texas Supreme Court, I'm sure this court is aware of this, has addressed these issues more globally in the Abshire case and the Beatty case, or the Beatty case in 2018. With regard to Dr. Adams's qualifications, he is a cardiothoracic surgeon with specialties in critical care management and emergent care and post-operative care for patients like Mrs. Nix, who are suffering from the kinds of symptoms and prognosis that she was suffering. He's clearly qualified to address those issues. His qualifications are well set forth in the actual report itself, and he is able to demonstrate his qualifications and familiarity with the standards of care that are required for the management of these conditions. More apropos, I think, to this argument is that he expressly discusses his familiarity with the standards of care for neurosurgeons who are then operating in a post-surgical environment for regular on the hospital floor management care of patients who have ongoing cardiac issues and that require attendant cardiac care. So that he has worked with these doctors in these environments before. He consults routinely with them. He actively practices in this area, and he is familiar with the care, not only for the condition at issue, but also the standards of care that should be applied by somebody like Dr. Chang as a neurosurgeon, who is also now functioning as a post-surgical manager of care.
Mr. Chaikin?
Yes, sir.
If I may, it appears that the trial court in the 3 reporters record, page 10, just said that he was qualified, but then her written order says something different, or at least Appellee has argued that it says something different. Could you please address that for me?
Well, I think at one point on the first go around with the trial court, Justice Peterson, there was some indication that the trial court believed that the practitioner who was giving the criticisms had to be of the same school of medicine or subspecialty. In other words, that it would require a neurosurgeon to opine about another neurosurgeon's care in this environment. I think over time, and at the second hearing, I think the trial court recognized, based on the briefing and the argument, that that wasn't necessarily the case. And then we cite cases in our brief that speak to that. You don't have to be of the same subspecialty. What's important here is that Dr. Adams was not criticizing the manner in which Dr. Chang performed his neurosurgery here. In other words, he's not evaluating whether or not Dr. Chang did or didn't do something properly with regard to this burr hole procedure, that he didn't do the right procedure, or that he did something wrong during this procedure to then cause, further complications. Instead, it's an inquiry solely based on Dr. Chang's involvement in the post-surgical care and the fact that Dr. Chang is essentially the captain of the ship here and managing this patient post-operatively. And so with regard to his qualifications, I do think the trial court ultimately recognized that he was qualified. It just isn't clear from the order. And so as a matter of prophylactic care here, I want to make sure that's addressed. I think the second part of the inquiry has to do with standards of care and the breach of standards of care and causation. And I'll combine all those given the time frame here. Dr. Adams has opined in this report that Dr. Chang has failed to recognize and respond to certain cardiac complications and changes that were on board with this patient. Those include the tachycardia, the shortness of breath, chest pain, one-sided weakness, and things of that nature. He opines that the standard of care requires him to be familiar with those things and to respond to them and recognize them, or consult with someone and transfer the patient to someone who can. And that didn't happen here. Dr. Adams says that Dr. Chang failed to obtain further consult, failed to transfer the patient back to the appropriate facility, and in fact, failed to verify that the patient was in fact appropriately ready for a discharge and that the active medical conditions were under control and there wasn't something severe or life-threatening that was on board with this patient. And the failure to do those things, Dr. Adams then opines, is what led to this patient's untimely, unfortunate, and unnecessary suffering and death. But Dr. Adams goes further, and really, in much like what Abshire talks about, and also the Wheeler case that was decided by this court fairly recently, and he prescribes the things that should have occurred with regard to this patient in terms of delivering diuretics, high pressure oxygen, intertropic medicine like dopamine, increased monitoring, possibly more for, surgery, the placement of a Swan's Gans catheter if necessary to alleviate some of this internal bleeding and to allow for the release of fluid around the heart. Any of these or all of these or some of these, Dr. Adams opines, would have been sufficient to change this patient's outcome, and not doing those things have contributed to or led to this unnecessary suffering and also this untimely death. I think, if the court needs to look no further at some level, if you wanted to reverse engineer this case, the most critical aspects here is that Dr. Chang verifies that this patient is ready for imminent discharge. He indicates that the patient is sleeping when he interacts with her, but yet he still verifies that she's okay and that she's stable and is ready to be discharged, when that just wasn't the case according to Dr. Adams at the time, and that Dr. Chang has a duty to verify those facts by looking at the medical record or otherwise. But once he gives that imprimatur that she's okay, that was her last best chance probably of avoiding this scenario. And who's right or wrong on that score is something that the Abshire court has indicated is a merit-based inquiry that will, excuse me, that will occur down the road. Thank you.
Thank you for that. And thank you for giving us 37 seconds back. Ms. Files.
Good morning, Your Honors. May it please the court, counsel. I wanted to, we are here representing
Before you go any
the
farther, would you go ahead and state your name and who you represent? I don't know if I asked the appellant to do that, but would you do that at this time?
Yes, Your Honor. Diana Faust here representing the Appellees, Dr. Chang, and the neurosurgical PA there. Now, thank you. I'd like to start out, first of all, just addressing quickly to the questions that were asked during the appellant's presentation. The first about what was Dr. Chang's knowledge. And yes, we do emphasize throughout our brief that based on this expert report and the medical records facts that Dr. Adams relied on in the report, that as of August 30th, Dr. Chang indicates that the patient is stable. Now, he does indicate in his progress note that the patient is asleep. The vital signs are normal, and if the court goes and looks back at the original report, which the trial court was allowed to review and could have reviewed, it said that the patient is stable with normal vital signs. The patient remains tachycardic, and after a repeat MRI is ready for transfer to a rehabilitation facility. Dr. Adams left out that last part in his supplemental report. However, it was before the court with respect to the original report, and all could be read together. So what did Dr. Chang know? As of August 30th, the record and the medical facts that are relied on by Dr. Adams is that her vital signs were normal at the time he examined her, and that sometime on August 30th and 31st, signs and symptoms of pain, shortness of breath that had been recognized earlier, and that the appellants fully acknowledged that Dr. Chang consulted with the cardiovascular surgeons to address.
Ms. Faust, those sound like excellent defenses at the merit stage of this litigation. But is it your position that you aren't, are you really saying that you don't have any, you can't understand what your client's being sued about based on this expert report? Yes,
Your Honor, because simply there's nothing in the report to show that Dr. Chang knew of these conditions on August 30th or 31st. In fact, look at the...
It's interesting you say that, because you say you appear to take the position that it is the plaintiff's burden to show exactly what Dr. Chang knew or didn't know before he can do any discovery. And one, he can't do any discovery until he submits the expert report. And two, that doesn't Dr. Chang owe a duty to know those things before he authorizes discharge? Aren't you basically isn't that a confession of his professional negligence? Well, how do we, the doctor didn't even know how his patient was doing. That doesn't appear to be a strong argument.
First of all, the report has to show within the four corners the medical facts that support the expert's opinion. Here, the expert states that Dr. Chang should have done something to intervene in the site of these symptoms, cardiac symptoms, and there's nothing in the report that shows that on August 30th or 31st, Dr. Chang was made aware of them. In fact, the report states, no, Your Honor, the report states that a physician, and Dr. Adams states that the physician was not named in the medical records, was contacted about these symptoms and ordered morphine. The report does not say that physician was Dr. Chang or that Dr. Chang knew about it.
Do you dispute Dr. Chang was the attending and treating physician for Ms. Nix on the day of her death?
There were many physicians involved in the care here, and in the report.
Objection, non-responsive. Do you dispute that Dr. Chang was Linda Nix's treating physician, attending physician on the date of her death?
He was a treating physician at the time of her death. There were many physicians, and the reporter's record at the hearing indicates, for example, that this whole captain of the ship doctrine, that is no longer a doctrine in medical malpractice law. In fact, again, many physicians involved in the care of this patient, many who had previously settled according to the record or were not sued. So to say that it was only Dr. Chang looking after this patient is inaccurate. And also, if you look at the original report compared to the supplemental report, you will see huge gaps of white space where obviously the report addressed those other treaters. And so when you come back in on the supplemental report and has tried to be limited specifically to Dr. Chang, then Dr. Adams had to come in and give some identification, some medical facts that are shown through the records that he reviewed and stated that he reviewed, that Dr. Chang had the knowledge on August 30th or August 31st about Ms. Chang's cardiac decline. Now, with respect to whether the trial court acted within its discretion in dismissing the case, the suggestion that the trial court dismissed the case purely because the counsel did not agree with Dr. Adams' opinions is not supported by the record. There was discussion of that. However, the court and the appellants noted even within their brief that the trial court did state that she was going to grant the motion to dismiss because there were just way too many gaps in the expert reports. For example, this huge gap of what Dr. Chang knew or didn't know or was supposed to know on August 30th or 31st. Now, if you go back and look at the expressions of opinions on breaches of the standard of care, for example, that is a very large factor in why these alleged breaches of the standards of care fail to provide the information and the specific conduct that's called into question here to show that the claim has merit, which is what is required. Without that knowledge on August 30th or 31st of what's going on, and by Dr. Adams' admission that an unidentified physician was called and prescribed morphine only, not that Dr. Chang was ever notified about it, then these breaches of the standard of care simply are contradicted by the actual facts that Dr. Adams relies on. And that is enough under the authority to render the expert report deficient. If we take the breaches that are alleged one by one, as we did within our brief, we have pointed out in detail how the report fails to link these opinions to the actual facts, the medical facts that are relied on in the four corners of the report. There's nowhere, for example, again, that no fact at all that shows that Dr. Chang was aware or demonstrates that he had knowledge about what occurred on August 30th and 31st, simply not there. The report again identified the prescription of morphine by an unidentified doctor, not Dr. Chang. No criticisms of Dr. Chang with regard to that. Failing to transfer Ms. Nix back to Baylor Heart Hospital after she was neurologically stable. No facts are provided in the report as to when she was neurologically stable. In fact, the original report, Dr. Adams indicates that Dr. Chang's note indicated she would be ready for transfer after a repeat MRI. So no facts about when she was neurologically stable or should have been transferred. So any alleged breach cannot be shown factually or has not been shown to be demonstrated through the medical facts shown in the records. And then the decision to discharge, again, reading the reports together, that in the face of the cardiac symptoms, no knowledge about those cardiac symptoms, Dr. Chang certainly indicating his intent for a repeat MRI. All of those facts are contradicting Dr. Adams.
How is Dr. Adams supposed to know that before he has had any opportunity to talk with any of the physicians or take anybody's deposition?
He cannot simply look at a medical record that does not show that Dr. Chang had knowledge and conclude that he did.
So
If
Dr.
he wants to
Chang does a
conclude
poor
that he
job of making notes. Dr. Chang doesn't clearly keep the best medical records. Therefore, he avoids even having to face a lawsuit for medical negligence when somebody dies the day he orders their discharge.
Respectfully, Your Honor, that's not been alleged here. In fact, it was the nurse's note that did not indicate which physician was contacted and
So
which physician ordered morphine.
Is that
According
Ms.
to
Nix's
Dr.
fault or the nurse's fault?
I'm sorry?
So Ms. Nix, because a nurse did a poor job, Ms. Nix can't even have a lawsuit about her death on the date she was ordered discharged. I want you to explain to me how Dr. Adams could have possibly known the things that you appear to demand that he know and put in his report. Wouldn't he? Because if you put those things into a report, I would hear you right now saying he was just speculating. He's just guessing about all of that. And if there's a records deficiency associated with somebody's death the day they're ordered discharged, without being able to take any depositions or even ask your client any questions, how is Dr. Adams ever supposed to be able to fairly describe what he, in his expert opinion, and the court appears to think his expert opinion is credible, at least from the record, how is he ever supposed to be able to accomplish the things that you're complaining about?
Your Honor, no lawsuit can proceed without the actual facts to support a breach. And so an expert has to rely on the medical records information, and there is no argument here that they did not have the medical records they needed. To simply come in and say that based on these medical records, Dr. Chang should have recognized cardiac symptoms without showing that he knew about them or was even aware of them, the four corners of the report has to show when did the duty start. He's aware of facts that put him on notice that he has to take some action. And that's where we fall short here. Are you in
the position that Dr. Chang had no knowledge of her prior cardiac issues?
Your Honor, according to this expert report, on August 30th and August 31st, there's nothing in here that states that Dr. Chang was aware that there was any decline or any change in the condition, that he was notified of anything. He's not there 24 hours a day by the bedside. He's anticipating an additional MRI. There's nothing in
Would
here.
it not be incumbent upon him to inquire as to those issues before he authorized her discharge?
The discharge was not authorized. If you read what he says about the progress notes, that the patient remains tachycardic, but after a repeat MRI is ready for a transfer. The discharge was not authorized on August 30th, and there's nothing else in the reports that show what happened with that MRI.
Other than her death?
Yes, but there's nothing to show that Dr. Chang was aware of any of that after the 30th. And for a duty to exist that was breached, there has to have been some information relayed to Dr. Chang. He is not at the bedside. He is relying on the nurses and the other practitioners who are there performing the MRIs and the physical therapy and all of these things to advise him of a change in her condition. And Dr. Adams does not state that that occurred. And without,
Ms. Faust, how are you doing?
fine, thank you, Your Honor.
Good. I've seen you for several years. Let me ask you a couple questions. This is so stilted doing this as we are through Zoom. So I'm not trying to load this up on you. I want to ask you my questions and then turn my microphone off, okay?
I understand.
Good with you? Okay. So on page 6 of the report, Dr. Adams says in the third, well, it's the second full paragraph, but it's kind of the third paragraph on that page. And I'm just going to read the first sentence. Further, the standard of care for a consulting neurosurgeon who has taken over management of a patient's care is to not discharge a patient without verifying all symptoms are managed, which here involved cardiac symptoms such as tachycardia, one-sided weakness, chest pain, and shortness of breath, or close paren, or otherwise under control. And again, if the symptoms are not under control, managed, and the standard of care requires a consulting neurosurgeon to consult with the appropriate medical professional, here a cardiovascular surgeon, to manage the conditions. Now, I'm understanding Dr. Adams to say in this report that what helps us know from the medical records that Dr. Chang is front and center on this cardiovascular problem, subsequent problem, the second episode. I mean, she comes in for cardiovascular surgery. But helps us know that there's a reoccurrence or an occurrence while under the care of the neurosurgeon Chang, is that when Chang authorizes the discharge or considers authorizing the discharge, whatever you want to say about that, he has a duty, says Adams in this report, to review the records and acquaint himself with what are her conditions, whether he's observing them or not. And then because of these conditions, which are enumerated, I just read them, his theory is quite simple. It's similar to a lawyer. If you and Mr. Chaikin were tax lawyers and a client walks in with a lawsuit and the client says, look, I don't really want to get a trial lawyer involved or my insurance company. Would you just negotiate with this plaintiff and get this thing settled? If you can get it settled under $20,000, get me out of here. And you miss an answer date. The tax lawyer misses an answer date. The standard of care is the standard of care of a lawyer who handles litigation, not the lawyer who handles tax matters. And how is that not what Dr. Adams is saying in this paragraph, as between a doctor who is a neurosurgeon versus a doctor who, when the patient is showing cardiovascular symptoms, you either got to treat them, and if you're not able to treat them, you got to refer her over to somebody who can treat them. That's their simple theory. And so I'm sorry I loaded that up. I'm using a lot of your time. And then under the more recent case that everybody is citing back and forth, Abishire, the Supreme Court seems to indicate where the plaintiff's theory is there should have been a referral to others to treat. If there is an articulation of what that treatment would have entailed and an opinion by a qualified person here, a cardiovascular surgeon himself, Dr. Adams, about what cardiovascular treatment she would have received, why does not Abishire say that's good enough? So I've burned up a lot of your time. Maybe our presiding judge would give you a minute or two more since I've used up so much of your time. Would you address that? Because that's my concern about this report.
Okay, let's take the second one first. If you look at Abshire and the articulation of what could have been done to change the outcome, if a referral had been made or something of that nature, that would go to the issue of, is the report sufficient on the issue of causation? And let's even say if it is sufficient on that end, because Dr. Adams included these, the types of things that could have been done to address these cardiac symptoms that a cardiovascular surgeon would have ordered, that only goes to the issue of causation. We still have the issue of breach of the standard of care, which goes primarily to your first question. And then, so you look at here, Dr. Adams is applying the standards of a cardiovascular surgeon to Dr. Chang, who is a neurosurgeon. And, but he never goes back to tie in how Dr. Chang, as a neurosurgeon, who is rendering post-surgical neurosurgical care. He's done surgery of the brain to take care of his subdural hematoma, and he never addresses how a neurosurgeon providing that post-operative care recognizes and should deal with the signs of cardiac distress, or to recognize the differences and make the determinations whether it's a cardiac distress or perhaps a post-operative neurological complication causing pain or weakness or that type of thing. Even in the initial report that Dr. Adams provided, another fact he did not really flesh out in the supplemental report, there were some suspicions that on August 30th or 31st, she was suffering from a TIA, a stroke, and that was not properly treated. However, there is no criticism of Dr. Chang in that respect. Again, I mean, I think at least it supports that things are happening with this patient. Care is continuing with the patient, and but Dr. Chang is not listed as the one who is having notice of that care, the results of that care, or to where he could take any action, whether he could go back. He had called the the cardiovascular surgeon in the past to determine when to start the Coumadin and the other type treatments twice. The appellants have agreed. He's done that. This is not a situation where we have showing through the facts in this four corners of these reports that Dr. Chang was aware, and therefore that the duty of a cardiovascular surgeon was triggered. So I hope that answers your questions, Your Honor. I'm going to rely on.
Did that cover Justice Evans?
Yes, thank you very much.
Okay.
I understand that my time is running out, but I do want to, we have tried to address each specific alleged breach of the standard of care within our brief. We have addressed causation, and even if Abshire cures or supports the way that causation was handled in this report, we believe that Dr. Adams was not shown to have been qualified other than with respect to what care should have been provided by a cardiovascular surgeon treating this patient. He didn't show that the neurosurgeon would have, that these were conditions that would apply across the board, so that he could then apply the knowledge of experience and training of a cardiovascular surgeon.
You're over your time. You can, I'll give you a few seconds to wrap up.
Thank you, Your Honor. We would ask the court to affirm the dismissal with prejudice in this case in all respects.
Thank you very much.
Am I unmuted?
You are. Please state your name and who you represent again for our
Yes,
recording.
I'm Robert Chaikin, and I regret and apologize for not identifying myself on the front end. I think I got kick-started. I represent the appellants, the estate of Linda Nix and her husband as well, Will Nix.
Thank you.
And I'll be brief. I don't know that I'll even use up my full 5 minutes here. And I want to start kind of general and then get down to a few specifics. From the broadest base here, 30,000 feet, the purpose of this scheme under Chapter 74 is to weed out frivolous claims, patently frivolous claims. These reports have to involve a good faith effort by the expert and need to contain a fair summary of all of the aspects of what is required at the outset of one of these cases without the benefit of full discovery or other information. And so this report is 8 or 9 pages of expressed detail about qualifications of this expert, about the standards of care that are on board, about how those standards of care were not met, about what could have been done and should have been done to satisfy those standards of care, either by Dr. Chang himself, if he's assumed the duty to take care of this patient, or if he had followed the other breach recommendation, which was to transfer the patient back or obtain more consult, then those folks could have done those things. But this report more than adequately meets those standards, on a broad, generalized basis. More importantly here, when you get down to it, almost any way you cut it, the argument here is really a merits-based argument that the appellees are making. And that is that, well, Dr. Chang, he just didn't know something and he didn't do anything wrong. And Dr. Adams is just incorrect. And in the process, what they're really, I think, saying, or at least what it sounds like to me, is that now they want Dr. Adams at this stage of litigation to literally read Dr. Chang's mind. And if I had gotten a report that said Dr. Chang knew something, and it was just based on Dr. Adams' belief metaphysically that Dr. Chang knew something, we'd be arguing about the fact that an expert can't make those kinds of conclusory statements. So the mere fact that Dr. Chang doesn't properly document all his records or confess in the records to what he knew or didn't know at a certain time is really a rabbit trail and is really a merits-based inquiry to be made down the road anyhow. But what is clear is Dr. Chang did visit, with Mrs. Nix right at the end of her course and did pronounce her suitable for discharge. And Dr. Adams says that was a mistake. That was a breach of the standard of care. He didn't verify that she was stable and ready for discharge, and that the result here wouldn't have occurred had he acted differently, not only then, but throughout his management of this patient as the attending physician. And one more thing, and I'll end with this, which is that the Abshire case and the attendant other cases that now discuss these Chapter 74 reports allow for the fact that the expert witness can even be wrong or incorrect at this stage of the litigation. They acknowledge that, in a sense, that this expert doesn't have all the information, doesn't have an ability to read people's minds, and doesn't have a full record, and that he may make opinions or conclusions that ultimately are proven incorrect, and yet the report itself is still sufficient to satisfy the requirements and the dictates of Chapter 74. And I'll give my remaining time back at this point. Thank you, Justices.
Thank you very much. This case will be submitted on the briefs and argument of counsel. Thank y'all for your participation in this Zoom in this trying time. This is the third one we've had here at the court. And if you wouldn't mind contacting Lisa Matz and letting her know if there's anything that we could have done better or differently to make this process go smoother. Any comments you have, if you could relay them to the clerk of the court, we would appreciate that very much. We thank you for your time. Anything you'd like to add, Justice Peterson or Justice Evans?
No, thank you all very much. Very good argument, very good briefs. We really appreciate it. Thank you.
Okay.
Thank you.
We will submit this case on the briefs and argument, and we will get you an opinion in due course. Thank you very much.
Thank you.